Ready? Start. It is further submitted that the notice dated 17/7/2015, which is said to have been sent by the complainant, was never served upon the applicant, as the notice itself does not show any date and time when it was served upon the applicant. Stop. Learned magistrate has also lost sight of the fact regarding the service of legal notice, which was returned back to the complainant unserved due to incomplete address of the applicant. Stop. The applicant in between 11/7/2015 to 24/7/2015 was under legal custody in connection with a case under sections 420, 467, 468 IPC, and was released on bail on 29/7/2015. Therefore, the service of legal notice dated 17/7/2015 upon the applicant does not arise at all. Stop. The legal notice was never served upon the applicant, and without service of legal notice, the proceeding U/S 138 of the Act against him cannot be initiated. Stop. It is further submitted that the complaint was also filed beyond stipulated period as provided under the Act. Stop. The complaint should have been filed within 45 days, but the same has been filed after 51 days. Hence, it is time barred and is not maintainable. Stop. It is also submitted that the opposite party number 2 has filed the complaint within the jurisdiction of Firozabad, whereas the applicant resides in Saharanpur, and he was not aware about the proceeding initiated against him, and as such he was not served with the summons and could not appear before the court concerned, on account of which, without issuing bailable and non-bailable warrant, the process U/S 82 CRPC has been issued against him. Stop. Therefore, the process U/S 82 CRPC is absolutely illegal and unjust. Stop. The entire proceeding initiated against the applicant in the absence of impleading the firm is vitiated in law. Stop. It is lastly submitted that no prima facie case is made out against the applicant, as the entire allegations made in the complaint are totally false and fabricated. Stop. Para. Per contra, learned AGA has contended that the complainant had suffered great loss of rupees 7,98,000, which has been paid by the applicant through checks, and the same has not been disputed by the applicant. Stop. Thereafter, the applicant had requested the bank for making stop payment of the amount, which itself shows malicious intention of the applicant to cheat the complainant. Stop. There is also no dispute that the check was not issued by the applicant. Stop. The applicant must have a sufficient fund in the account of the date of signing of the check, but when the check was presented, the amount was found insufficient in the account of the applicant. Stop. Hence, the burden of providing that the check was not dishonored on account of insufficiency of fund is on the applicant, and on this ground the complaint filed by the opposite party number 2 cannot be quashed. Stop. It is further submitted that instead of giving reply to the legal statutory notice after the check was returned with the endorsement of insufficient fund, the applicant could have given the explanation disowning his liability to pay any amount. Stop. Over.